and you will know all of the minor name changes. So what this bill does is makes it so that those documents are not publicly accessible as they are now. It does not change any of the guardrails that are already in place to address if a name change was being made for purposes of fraud.
Senator Kolk, we're good for now? All right, members, other questions of this panel? Seeing none, thank you for testifying with us. Ms. Fiera, thanks for being with us online. Okay, now I'm going to call folks who signed up indicating an opposed position. Apologize in advance if I mispronounce any names. First panel, Erin Lee. Lori Gemelstein. And I've got to apologize. This list doesn't indicate who's in person or who's online, so these may be mixed panels. Roy Epen, Brittany Vesely, and Travis Morrell. And we'll just start at the end. Ma'am, please go ahead.
Thank you, Mr. Chair and Committee. My name is Erin Lee, representing myself. I'm here as a mom who in 2021, I almost lost my little girl because I dared to tell her the truth, that no child is born in the wrong body, that there's no wrong way to be a boy or a girl, and that I would not consent to life-altering psychosocial transition or irreversible physical harm simply because she was struggling with awkwardness, puberty, and moving to a new school during COVID. My daughter, Chloe, was recruited into a secret GSA in 6th grade, sexualized, transitioned into a boy by trusted adults, and taught to keep it all a secret from me. When she broke that rule and told me what she was going through, we did not affirm. Because of that, we received a well-child check from CPS. We had teachers, doctors, and even friends push the suicide myth that you must affirm your child or they will kill themselves. Her therapist was forced by House Bill 19-1129 to push her further down a path of confusion, self-hatred, mistrust of her parents, and unnecessary medical harm. We were gaslit and bullied. We watched wrong sex confusion take hold of our child to the point that she wrote us a suicide note. She wanted help being comfortable with herself, but the laws and systems you have built made us, her parents, the only ones standing between her and irreversible harm. I dared to tell my little girl that she was not a boy named Toby, and I almost lost her for it. I know that I'm one of the lucky ones. I've met so many parents right here in Colorado who have lost their children partially or completely for not affirming wrong sex confusion. I know fathers who will be here today watching their kids be put on chemical castration drugs, terrified to speak up because they could lose their child entirely. This system is already stacked against them. Telling your child the truth and protecting them from medical harm is not child abuse. It is what good parents do. It should not be grounds to lose your child. The state does not know what's right for our kids. I understand you struck Section 2, but just as I sat right here last year and you struck it, it was brought back with this bill and it will surely keep coming back. We already know this is common practice in CPS and family court. You will hurt so many more families like mine with this bill. Please stop this. I urge a no vote.
All right, ma'am, in the middle, please go ahead. Great button on the stem.
Wrong button. Thank you, Chair and members of the committee. My name is Lori Gemelstein. I'm the Executive Director of the Colorado Parent Advocacy Network, and I am here today in strong opposition to Senate Bill 2618, even with the strike of Section 2. Last year, this legislature introduced House Bill 2513-12, and as written, it explicitly framed a parent's refusal to affirm a child's newly declared gender identity as coercive control, a form of abuse that could cost parents custody. Families across Colorado saw exactly what this meant, and they responded. In less than 72 hours, more than 32,000 Coloradans signed a petition in opposition. Over 500 people registered to testify against this bill compared to roughly 200 in support. Parents came forward to explain that simply saying, wait, let's understand why you're feeling this way, was being treated as grounds for state intervention. After national media coverage and intense public pressure, the Senate Judiciary Committee struck the coercive control language. We were told that parents have been heard, but I warned the committee that very night in this very room, and my testimony and letters are part of that public record, that striking the language did not change the intent of the bill. It merely changed the vehicle. And today that warning has proven accurate. I understand this committee might strike Section 2. This does not erase the legislative intent, and it does not restore our trust, nor does it negate the fact that this governing body attempted another bait and switch. You are not undoing Section 1. There are alarming secrecy provisions in addition to gender identity being added through 1239 last year in the Colorado Anti-Discrimination Act, turning deeply personal family conversations into potential legal violations. I want you to pause on what this means. It means a child in distress can be separated from the one place that should be safest, home. Not because of abuse or neglect, but because a parent chose patient discussion over affirmation. When the state separates a child from a loving parent over ideology, the damage does not end with a court order. It follows that child for life. Please do not make that harm the law.
Thank you. Ms. Vesely, please go ahead.
Thank you, Mr. Chair. My name is Brittany Vesely. I'm the Executive Director of the Colorado Catholic Conference, testifying in opposition to SB 18. This body has expanded the Colorado Anti-Discrimination Act, or CAUDA, 3 times in 4 years, starting with HB 21-1108, which expanded protected classes to include sexual orientation, gender identity, and gender expression. The law included a religious liberty exemption limited to the 4 walls of a church building, making all other places of accommodation liable to CAUDA. In 2024, the legislature enacted HB 24-1124, which added a financial penalty to criminal penalties for discriminating against CAUDA. Last year, HB 25-1312 was enacted, which added new definitions of dead naming and misgendering to enforceable actions that are CAUDA. HB 1312 originally allowed courts to consider if parents were practicing coercive control for opposing their child's professed gender identity and determining custody decisions. Over 700 Coloradans came to that committee in opposition. As they have today, the parental custody section was stripped out of this bill because of the community outcry. Despite the amendment today, SB 18 once again has targeted parents who do not affirm their child's trans identity. Both seal name changes without parental consent and threaten the use of court order to remove children from their parents' custody if the state determines parents' sincerely held beliefs on human sexuality discriminates against transgender ideology in CAUDA. The sponsor made it clear that she wants the parental custody question brought back very soon. This is a massive violation of First Amendment constitutional precedent protecting parental rights from state overreach, including Ch1ld v. Granville, which held that parents have a fundamental right to make decisions concerning care, custody, and control of their children, and Stasi v. Kramer, which held that state cannot take away parents' rights without clear and convincing evidence. This is why SB 18 is vulnerable to U.S. constitutional and case law, and why Section 2's stricken line subject to constitutional limitations was added. In some of the darkest chapters of history, including under Germany's Nazi rule, the state separated children from their families because of identity. We should be concerned whenever state policy is to remove children from their family, not for abuse and neglect, but because parents of children disagree about personally held beliefs. On behalf of the Colorado Bishops, please vote no.
Thank you. We'll go online to Dr. Evan.
To the chair and the members of the committee, thank you for allowing me the opportunity to speak today. My name is Dr. Roy Epen. I'm a board-certified endocrinologist from Montreal, a fellow of the Royal College of Physicians, the American College of Physicians, and the American College of Endocrinology. I'm an assistant professor at McGill University, although my testimony today is neither representative of my university nor group affiliations. I'm also a member of the LGBT Courage Coalition and a senior fellow at Do No Harm Action. The number of kids and young adults transitioning in the last few years has skyrocketed. And while the Dutch protocol, the original standard of procedure for treating gender dysphoria, called for extensive psychological evaluation before transition, these safeguards have been cut way back in North America. In recent days, we see that many medical associations are expressing the same level of doubt as I do. The American Society of Plastic Surgery has recommended that these treatments not be undertaken until age 19. The AAP and the AMA have both said they broadly agree with those changes. As I've written before, there is no consensus in these treatments. The UK and many Scandinavian countries are also severely cutting back on these drugs and surgeries. The recent $2 million judgment in NYC is further evidence of the fact that this is not reasonable care. So I oppose this bill mostly because, as my previous speakers have said, that these amendments can be brought back quite quite easily. And children's strongest advocates and most valuable protectors are their parents. And I don't think that we should allow parents to be separated from their children because they disagree on an issue that has no evidence for their treatment. Thank you for your time, and I welcome any questions.
Okay, thank you. Committee questions of this panel. Senator Carson.
Thank you, Mr. Chairman. This question's for Brittany Vesely. You mentioned the issues with CADA, Anti-Discrimination Act, and can you just put a little bit finer point on how you feel this legislation would continue the problems you're seeing with that?
Ms. Vesely.
Thank you, Mr. Chair. Thank you, Senator Carson. Throughout Senate Bill 18 is reference to CADA. This is clearly an expansion of the Colorado Anti-Discrimination Act, or CADA. And as I mentioned, in 2021, HB 21-1108 redefined Colorado's Anti-Discrimination Act, or CADA, to include sexual orientation, gender identity, and gender expression as new protected classes in state law. CADA's definition of places of public accommodation excludes a church, synagogue, mosque, or any other place, quote unquote, principally used for religious purposes from the statute. That's the only religious exemption, which means CADA applies to every individual in the state of Colorado and any nonprofit that is not the four walls of a church building. The scope of this protection, therefore, is uncertain. We do not know if judges will include religious schools, faith-based social service providers as principally used for religious purposes. The precedent suggests not. Additionally, HB 21-1108 and HB 25-1312 last year provide no protections for private individuals who practice their well-founded convictions on human sexuality in the public sphere, which brings back the 2017 U.S. Supreme Court case Masterpiece Cake Shop v. Colorado Civil Rights Commission, in which Masterpiece Cake Shop owner Jack Phillips was sued for politely refusing to design a wedding cake for a same-sex marriage due to his religious beliefs on marriage. The Colorado Civil Rights Commission found that Jack violated the anti-discrimination law we're discussing. However, in a 7-2 ruling, the U.S. Supreme Court found that Colorado was wrong to punish Jack for peacefully living out his beliefs. HB 21-1108 gave that authority to this Colorado Civil Rights Commission to decide how to enforce religious expression and worship, and how they're applied to our religious institutions and to private citizens, which means it codifies discrimination against anyone with a different belief about human sexuality. Even sealing records is an expansion of the Colorado Anti-Discrimination Act, because parents do not have a right to consent to this change for their minor who is under 18 years of age. And as I mentioned, the sponsor already stated at the beginning of this hearing that she will bring this bill back again and remove parental rights from their children under the age of 18 due to a disagreement on gender ideology, citing the Colorado Anti-Discrimination Act. So this is why it's a continuation of CADA, the Colorado Anti-Discrimination Act.
Thank you.
We're good for now.
Thank you.
Senator Zamora Wilson with a question.
Thank you, Mr. Chair. This is for Ms. Erin Lee. You mentioned about your daughter. How do you think this bill, if it was in place law, how do you think that would have impacted your situation? And you please elaborate on the other bills that would have impacted. Thank you.
Ms. Lee, I'll invite you to respond as to this bill we are speaking today, to Senate Bill 18. It's best if we confine our testimony to that rather than other things the General Assembly has considered whether or not adopted. Please go ahead.
Thank you, Mr. Chair. Senator Wilson, thank you so much for the question. I do firmly believe that many factors were at play that contributed to our ability to keep custody of our 12-year-old daughter that day, one of them being our mandated reporter was not a believer in affirmation. And so thank God we didn't have her forcibly removed from our custody at 12 years old that day. But every parent I have met besides us has not been so lucky. There's a dad here in the room that's going to testify today. You may have heard of the Cindy Stein case in Durango, where she lost custody of her minor child into the arms of the teacher who had groomed her. There's another family in Rifle, Colorado, who lost custody of their 17-year-old daughter. Emergency custody order was granted, again, to an activist that the parents had never met, who were willing to affirm when the parents weren't. That little girl was then immediately medicalized with wrong sex hormones at a high dosage. And then they filed restraining orders against the parents when they continued to refuse to affirm. So those are just a few examples of parents who have not been as lucky as I have. That's why I show up to testify on behalf of them. There's another brave dad, Jason Zook, who testified last year against 1312. He's a dad of a 6 and an 8-year-old, a leftist voter, a public school teacher, and his spouse suddenly transitioned both of the boys into non-binary and transgender. And when he found himself at Children's Hospital, Colorado, with his then 9-year-old, they were forcing puberty blockers onto the child. When the dad refused, he was taken to court, and because he represented himself pro se, he lost custody of both of his kids permanently. They are now 14 and 16, and he has not talked to them in 6 years. So this is already standard practice in the family court system with child protective services, in our schools, in our NGOs. It's widely recognized in every system that if a parent will not affirm, they are not a fit parent. And I am living testimony that the opposite is true. Affirming my daughter would have taken her life. In fact, she recently spoke at one of Ms. Gimelstein's events where she was asked, if your parents had affirmed you, where do you think you would be today? And she said, if my mom had affirmed me, I don't think I would be alive, because transgenderism didn't offer any of the happiness that I was sold. It was a dark path devoid of any of the promises that I was given. So if I had affirmed my daughter, she wouldn't be alive today. She would not be a happy, healthy, thriving 16-year-old girl. So I know the ramifications of removing children from loving parents. It's happening all over the state, and to put it into law would be the final nail in the coffin to make sure that parents like me, even in 2-parent loving households, do not get to lovingly and responsibly parent our children.
Members, other questions of this panel? Seeing none, thank you for testifying with us. Okay, next panel, Dr. Susan Selner-Wright. Dr. Lyrad Riley. Kristen Muzzy, M-U-Z-Z-Y. And Dr. Virginia Weaver. Okay, looks like we're getting folks connected online. Ma'am, we'll start in the room with you. Let us know your name, affiliation, if any. Please go ahead for 2 minutes. Then please hold the table. We'll hear from our online witnesses. Then we'll go to questions.
Okay. Good afternoon, Chair and members of the Judiciary Committee. My name is Kristen Muzzy, and I am a parent and a concerned Colorado resident. I strongly oppose SB 26-018, even with the amendments and striking out Section 2. While the bill's title speaks of dignity and privacy for minors, such as suppressing name change records for those under 18, its core provision on custody is deeply troubling and dangerous. The bill requires courts to consider whether a parent recognizes the child's identity as it relates to a protected class when deciding parenting time and decision-making responsibility. Protected classes include gender identity and gender expression. In practice, this creates a loyalty test. Parents who affirm a child's claimed gender identity get preference, while those who often for religious, medical, or conscience-based reasons cannot or will not affirm it, risk being labeled as harmful. This isn't neutral. It inserts state ideology into private family disputes, even absent any evidence of abuse or neglect. A loving parent could lose custody or significant time with their child simply for believing biological sex is real or for wanting more time and evidence before irreversible medical steps. This undermines parental rights, which the U.S. Supreme Court has long recognized as fundamental. Last year, similar language was stripped from another bill after massive public outcry. Reviving it here quietly is not progress. It's an attempt to bypass that opposition. SB 26-018 risks tearing families apart, chilling free speech and belief in homes, and prioritizing ideological conformity over the actual best interests of children, which should include both parents' perspectives unless one is truly unfit. Please vote no on SB 26-018 to protect parental rights and keep government out of families' most personal decisions. Thank you for your time and for your service.
All right, thank you. Please hold there and we'll come to questions at the end. All right, Dr. Riley, please go ahead.
Hello, my name is Laird Riley. I am a practicing family physician in Western Colorado in Grand Junction. I've been taking care of patients of all ages for about 25 years, the last 8 here in Grand Junction. I have provided primary care for many patients with complex psychiatric issues, including transgender. I understand that there's been recent changes to this bill just today to remove the most concerning provisions, but to ensure that they're not added back through amendments, as the sponsor indicated she'd like to do. I appreciate this opportunity to testify before this committee. I think we can all recognize that good people, well-meaning people, and the organizations they presumably represent disagree strongly about the harms to children in performing procedures and providing hormones to minors. This bill's language about factoring a parent's acceptance of their child's current gender identity in determining time spent with their children and decision-making, medical responsibility, this can potentially alienate these caring parents from their children. I've worked with many families undergoing situations including anxiety disorders, depression, bullying, gender confusion, and putting into law a tool to divide parents from their children is wrong. Though there's, of course, unfortunate exceptions, generally speaking, no one cares more or has more obvious right to guide and protect their children and parents. Many parents recognize the long-term harms of disfiguring surgeries and puberty blockers and hormones given to children. And this bill places ideological preferences above natural family relationships. So I urge people to vote no on SB 26-018. Thank you.
All right, thank you. Dr. Wright, please go ahead.
Hi, can you hear me?
We're hearing you fine. Please continue.
All right. I will argue against the previous language of 26-018 and any attempt to bring that language back because it endangers a parent's custody of a minor child in a way that is simply irrational. A parent can have perfectly reasonable hesitance to affirm a child's transgender self-identification. A parent's hesitance is perfectly rational given that the science shows that such affirmation almost guarantees the child's progression to life-altering, irreversible medical procedures to which the child does not have the developmental capacity to reasonably consent. And for this, the industry's own data shows this very clearly. And the science cited by those who are pro-affirmation is widely recognized to be prima facie substandard. As just the most recent example, you can see the American Society of Plastic Surgeons February 3rd statement, which concludes that, quote, there is insufficient evidence demonstrating a favorable risk-benefit ratio for the pathway of gender-related endocrine and surgical interventions in children and adolescents. So in conclusion, to have this continue to come up and for the legislature to adopt this sort of language would be taking the side that is not supported by the science in support of an ideological view of the human person, which is novel and which poses great danger to the well-being of children. Your constituents deserve better, and I'm sure all of us who are here to testify will be back if this comes up again. Thank you.
All right, thank you. Dr. Weaver, please go ahead.
Hi, Mr. Chairman and distinguished members of the committee. My name is Dr. Virginia Weaver. I'm a surgeon in Memphis, Tennessee. Thank you for allowing me to testify in opposition, especially to the language of this bill that the senators indicated could be added back in. That language does not protect the dignity of minors. It punishes the parent who says no to the experimental, irreversible, sex-altering interventions on their own child. It brands as unfit or worse, abusive, the mother or father who refuses puberty blockers, cross-sex hormones, or surgery for their child who is still developing physically and emotionally. I would urge you to reject any language that strips parenting rights from the parent who actually does the research, the parent who has read the CAST report and seen its sobering conclusion that there is no evidence that these interventions improve long-term health. The parent who knows the Tavistock Gender Clinic for Minors in Britain was shut down because of the devastating outcomes there. The parent who has studied the May HHS report on the review of evidence in pediatric gender dysphoria. The parent who is aware of the FTC active probe into both WPATH and the AAP for fraud. The parent who followed the United States Supreme Court arguments in which Tennessee's Attorney General defended safeguarding minors, leaving the justices stunned at the glaring lack of evidence. That informed parent is the one that this bill seeks to punish and silence. Meanwhile, the parent who ignores every red flag, every piece of medical evidence, and is willing to rush their child towards sterility and lifelong medical dependence is handed the legal protection. That is clearly not the best interest of the child. That is ideological capture masquerading as compassion. As you know, several medical organizations have already withdrawn or restricted their support for these interventions in minors, and more will follow. Detransitioners, young people whose healthy bodies have already been irreversibly altered, are now flooding the courtrooms with lawsuits. This bill is not neutral. It is.
Ma'am, thank you. You're over time. I'm going to ask you to conclude. We'll see if the committee has questions of any of our witnesses.
Sure.
See no questions. Thank you all for testifying with us. Okay, next panel, Antoinette de la Cruz, Melissa Ogburn, Dr. Catherine Wheeler, Glenn Stanton. All right, as we've been doing, we'll start in person. We'll just move down from, I guess, this end. Ma'am, if you want to start us off, let us know your name and affiliation. Please go ahead.
Thank you, Mr. Chair and members of the committee. My name is Catherine Wheeler. I'm an OBGYN physician, and I'm representing myself. I was prepared to testify about the second section, but that is, I understand, been stricken. I share the concerns that have been voiced, that there seems to be an intention to continue to bring this back. I believe that the physicians who spoke very accurately in what I was prepared to present. So I will simply say children have a right to both of their biological parents when possible, that removing or limiting parents' responsibilities and or rights is a serious undertaking and should only be done under the most serious circumstances. Even name changes should be under a parent's purview until their child is legally an adult. Not a single citizen or parent I have spoken to agree with the Colorado legislature intervening in their rights and responsibility to raise their children and act in their best interest. In fact, my own son and his family recently moved from Colorado because of these fears, which were very real, as we heard from Erin Lee, that they could not protect and raise their children as they wished to here. I have a grandson with special needs who was already being targeted. This government interference has to stop. I ask for a no vote.
Thank you. Sir, please go ahead, then we'll go to our online witnesses.
Yeah. Chairman Weisman, members of the committee, thank you so much. My name is Glenn Stanton. I am a social researcher at Focus on the Family in Colorado. I have lived here since 1993, and I've studied adolescent gender identity for over 2 decades. SB 18 is an ill-advised bill, even with Section 2 taken out. The governor's office chose last year to pull this proposal at the final last hour because of negative media and community blowback. We seem to have done that again, but we've been promised that it will come back. So I want to testify against that section. If this bill is so essential for child well-being now, why not last year and why not this year? This bill will cut a vulnerable child off from the parent or parents they need most, those who do not unquestionably accept a child's new identity. The reasons for this are clear, and I want to name three. First, the best research regularly documents that overwhelmingly most youth who believe they are trans come to live peaceably with their biological sex before reaching puberty. Something that is most likely to change that fluidly cannot be a protected class. Number two, the American Psychiatric Association readily admits that transgender, quote unquote, is neither a medical nor psychiatric diagnosis. And I have the documents right here where they state that. It is something science cannot It is not something that science can recognize because it is a subjective self-perception and ideological construct. That is why desistance rates are thankfully so high. Number three, as we've heard here today, two medical organizations already that were once supportive now refuse hormonal and surgical interventions for children and adolescents. The American Society of Plastic Surgeons and the American Medical Association announced on February 3rd that there is insufficient evidence for guaranteeing safe interventions like this. I ask for a no vote on this, and I ask that this effort
thank you.
to alienate parents not come up again.
We're going to go online. Please hold the table in case there are questions. Ms. Ogburn, please go ahead.
Good afternoon, and thank you, Chair and committee members. My name is Melissa Ogburn, and I am here to testify in my own personal capacity. I reside in Senate District 16, and I'm a registered Democrat. I'm here today to ask you to vote no on Senate Bill 18 because it cuts parents out of the process of name changes for minors. I'm also an attorney practicing amendments, and my comments remain unchanged. Senate Bill 18 is unconstitutional and defies not only the First Amendment, but also the 14th Amendment. In recent years, this legislative body has pushed through unconstitutional legislation at the extreme expense of the citizens and taxpayers of Colorado. Just earlier this year, a federal court ordered Colorado to pay over $5.4 million in attorney fees and costs for an unconstitutional attempt to ban abortion pill reversal. Whatever your thoughts are on APR, forcing a $5.4 million judgment on taxpayers is unconscionable. This follows a 2024 for violating constitutional rights regarding religious freedom and free speech. So in just the past 1.5 years alone, Colorado has been ordered to pay nearly $7 million for violating constitutional rights. We, the people of the state of Colorado, cannot tolerate another blatant violation of constitutional rights. Senate Bill 26-018 is unconstitutional. In Ch1ld versus Granville, the Supreme Court cited now 100 years of jurisprudence recognizing that the liberty protected by the upbringing of their own children. In Pierce versus Society of Sisters, the Supreme Court held that the liberty of parents and guardians includes the right to direct the upbringing and education of children under their control. Senate Bill 18 is unconstitutional violation of parental rights and freedoms of religion and speech. It invites costly lawsuits and severe penalties that constituents should not be burdened with. I ask you to vote no on Senate Bill 26-018, and I'm happy to take any questions. Thank you for your time this afternoon.
All right, thank you. Please stay on the Zoom for a bit for questions. We'll go first to Ms. De La Cruz.
Hello, committee members. My name is Antoinette De La Cruz, and I'm here today to urge voting no on SB 26-018 because it creates a dangerous precedent that undermines the fundamental rights of parents and the safety of Colorado families. This bill I know has been amended today, but I still have concerns for it being reintroduced, as this weaponizes a child's self-identified identity against their own parents. This bill shifts the best interest of the client standards towards a state-mandated ideological litmus test. This bill also infringes upon the First Amendment. Under this bill, recognition could be interpreted as compelled speech, forcing parents to use specific names or pronouns against their own conscience. The government shouldn't be allowed to have the power to dictate how families navigate these deeply personal and sensitive conversations. Finally, we must consider the risk of unintended harm. By prioritizing immediate affirmation over a parent's guidance, we risk cutting out the very people who know this child best. This bill creates a one-size-fits-all legal requirement for a complex psychological situation or situations that require parental nuance, not judicial interference. Protect the integrity of our family unit and the rights of Colorado parents, and please vote no on SB 26-018. Thank you.
All right, thank you. Committee, are there questions for our witnesses? Mr. Vestier.
Thank you, Mr. Chair. Not really a question, and thank you all for your testimony. Just a point of clarification and in response a little bit to the gentleman's comments about something coming back into this bill. I just want to clarify, and I know you all haven't maybe seen the printout of the amendment, but the amendment not only strikes Section 2, but it also narrows the title of the bill to remove any language referring to parenting time or the family court process. It's a pretty hard and fast rule in this building that title